CRPC, that is Criminal Procedure Code. Now, here when we take up the discussion on Criminal Procedure Code, during investigation police has a power to secure the attendance of the witnesses, and this is for the purpose of investigation. However, the police power to secure the attendance has been substantially restricted when it comes to the witnesses, if they are, when it comes to women witness and the child witness. So, here they are providing an exemption where a police cannot summon women or children to the police station. If at all there needs to be interrogated, questioned, then the police has to go to the place where the women or the child is residing. So, therefore, with this provision, all women, whether it is a girl child or a grown up, are protected against the visiting of the police station, and a child, male or female, below the 15 years of age cannot be called to the police station. The object behind this is the law feels that the person, the child, should not be exposed to the intimidating atmosphere and the conditions at the police station. Further, in CRPC itself, there is a provision for examination of victims. So, when it comes to examination of a female victim, it has to be conducted by a female medical examiner, a registered practitioner. So, therefore, there is a protection of a dignity to a girl child, but it is extended to all women, but we can also consider it as a girl child is protected under this provision. At the same time, let us take up the last provision, that is about the locus standi. Now, locus standi is who can move the investigation proceedings under the criminal law. It is the victim only. A victim who has suffered a crime should go approach the police station and initiate the proceedings. If not, the other people, the general public, are prohibited from initiating the criminal proceedings. The exception is created if the victim happens to be below 18 years of age. So, in such situation, any person, the person who is having information about the violation can initiate criminal proceedings. It is possible only if the victim is below 18 years of age. Then law of evidence. So, law of evidence, in this the special provision for the child is taken only in case of witness. So, witness is a very important part of a litigation process, and witness generally is subjected to a kind of intimidating questions and other things. So, whether a child could be a competent witness. So, in this case the law says a child with a tender age, please note that there is no age fixed under law of evidence. A child of a tender age, if it finds or if he is not in a position to understand the questions, understand what answer to be given, then such child cannot be taken as the witness. So, therefore, there is a kind of a protection granted to the child at the cost of justice. So, here why child interest is protected rather than the justice. Now, here again there is a choice made by the law. If child is allowed, there can be miscarriage of justice. If child is not allowed, again there are chance of miscarriage of justice. So, either way the chances do exist. So, therefore, they prefer to protect the interest of the child, and the burden is put on the prosecution to find out the other way, tedious way to come to justice. Legal Service Authorities Act also provides a provision for protecting the interest of the child in the form of providing legal assistance. So, the Legal Service Authorities Act gives a list who are entitled for the assistance. In the list there is child or children name is present. So, they can access the legal services. So, these are about the general provisions where child rights have been protected, access to justice for the children is being encouraged. Let us move on to a little serious note on grievance redressal mechanisms. So, when a child is being a victim or being accused of a crime. Under such circumstances, how the law take into consideration. So, under this discussion, the first law which I am going to take up for the discussion is Commission for Protection of Child Act 2005. Now, this act is being established in the line of Human Rights Commission Act. So, like Human Rights Commission, here two commissions are established under this legislation, that is the National Commission for Child Rights and the State Commission for Child Rights. These commissions are non-adjudicatory authorities, they are only recommendatory bodies, and they have power to conduct investigation and inquiry into the provisions, into the incidents, and after conducting inquiry and investigation they can give the recommendations. In case any specific cases come before these commissions on behalf of the victim can move the court. They can go to Supreme Court or the High Court and seek for a proper directions in the form of writ. The commissions enjoy the power of civil court for the purpose of conducting investigation and inquiry, which generally include the power to issue summons, power to examine witnesses, power to examine the documents connected with the dispute, as well as power to enter the premises for the purpose of investigation. In addition to these powers, there are responsibilities that has been attached with these commissions, which include responsibility to protect the child in distress, child of marginalized and disadvantaged group. So, the child in distress could be a victim of a crime or may be accused of a crime. Marginalized and disadvantaged group could be a child belonging to economically backward section, socially backward section. So, these children needs to be taken care of. Children in conflict with law, that is the accused child. The children without family, so who is in need of care and protection. So, the commission is under the responsibility to provide support for such kind of children. And finally, even they have to extend the help to the children of prisoners. So, the responsibility also include that wherever these children in need of help are been put up, they can periodically conduct inspection and find out the status of the children. In addition to the commissions, the Act also provides for establishment of children's court. In this children's court, the Act provides that any district court could be designated as a children's court, and in this children's court any offences committed by the child could be tried, or any victim of a crime could be tried. So, a sessions court could be recognized as a children court, and each children court will have special public prosecutor to represent the children. Moving on to the next act, that is Protection of Children from Sexual Offences Act 2012. There is two things that we should keep in mind, that it is applicable only to the girl child, and that too a girl child who has suffered or who has undergone sexual abuse. And this is another fact that is to be kept in mind, is this is the only legislation which is been enacted keeping the victim child in the mind, or else all these days or all these legislations take accused child in mind, and there are protection granted to the accused child. So, wherever, so the child, the girl child is prone, or even a male child is prone for sexual abuses due to lack of knowledge of sexual advances. Secondly, the offender prefers the child could be intimidated easily from keeping the incident secret. So, therefore, the child, generally girl or boy, are subjected to sexual exploitations. So, the Act provides for reporting and investigation process where any person who has the knowledge of such incident could report to the investigation officers. So, there is no need for the child herself or the parents of the child should initiate the criminal proceedings. The additional provisions which are there for protecting the interest of the child is that the recording of evidence should be done in the language of the child, which the child is having the knowledge of it. The statement should be recorded at the residence of the child, not at the place where the police wants or at a place where the child feels comfortable. During recording of the statement, the police are not allowed to wear their uniform. So, they have to be there in a plain clothes. And in addition to these things, there are few additional provisions which go in a long way in protecting the interest of the child. That is, every witness, that is when the child is interviewed, the interview should be audio and video recorded, so that child need not go through the trouble of recollecting the incident again and again. So, the audio video recording would help the investigators to continue with the investigation. The identity of the child has to be protected, it cannot be revealed at any cost. The parent or the guardian must be present when the child is interviewed or when the child is medically examined. The girl child should be examined by the lady medical practitioners only. So, from this sexual offences act, we move on to child victim of a domestic violence. So, Domestic Violence Act 2005 provided for the protection for women and a girl child against the domestic violence. Home is a most safe place on earth for a child, but if the same home turns out to be a hell, a source of agony, a source of torture, then the child would be suffering mental torture in addition to the physical sufferings. So, therefore, such child needs additional protection. So, here in this Domestic Violence Act, as the act being a civil legislation, here there are no criminal remedies provided. So, there is no punishment as a part of the remedy, but there are various other remedies that they are provided under this. The remedy seekers or the beneficiaries under the act can be a woman or a girl child, as the scope is limited only to the female of a household. So, the reliefs could vary from protection orders, where the order could be passed by the court to protect or to not to interfere with the life of women or the child. The offender or the aggressor could be instructed strictly not to interfere with them, stay away from them, not to enter a specific premises for a specific time. Such protection orders could be passed. Residence order: if a girl child or the mother women is asked to leave home, they have got a right of residence in the same house, they can continue to stay. Monetary reliefs could also be asked for continuation for sustenance. Custody orders: in case the women or the mother and the father are separated, and the custody could be granted under the Domestic Violence Act 2005. Compensation order could also be added into this process.